I'm not trimming nothing today out in the snow.
Yeah.
It is not welcome.
Greasy out there.
Good morning. So today is Wednesday, April 21st. It's 10:31 a.m. This is the second half of the morning session of Senate Natural Resources and Energy. And we are returning to the topic of the scuttling or reefing of the ship Adirondack and the lake encroachment issue, and wanted to pick up where we left off. So let me, sorry, I'm opening screens at the same time as I'm talking. It's not working that well. The last time we were talking about this, I think where we basically left it is that a permit was issued by ANR for this project. I think it was March 25th, but therefore, a permit having been issued, rights vested at the time of a complete application, we're not going to get involved in challenging a permit. That's not our role. Other parties may choose to do so, but the legislature is instead focusing its energy looking forward to address the issue of lake encroachment and maybe another application like this one. So with that, we had asked Michael O'Grady to please draft an amendment. And so with that, I'd like to ask Mr. O'Grady to screen share, fill us in on any kind of legal context for what we're doing here, and walk us through the amendment.
So you know that under 29, Title 29, there is the declaration that the lakes and ponds of the state are to be held in trust, and the authority to manage those and encroachments on those lakes and ponds was delegated to DEC for them to issue permits when they've determined that the encroachment is in the public good. And there is a statutory section that gives some basic guidance on what constitutes the public good. In addition, and you may not have heard this as of yet, the department does have an interim procedure for the issuance or denial of encroachment permits. It was issued in 1989, so it's 32 years old. It likely never went through a public participation process, and technically as a procedure doesn't have statewide binding effect. So what is in front of you and what the committee is proposing is to require the department to adopt rules to implement the requirements of the encroachment chapter, and to give criteria for what they need to address in the rule. And putting together the amendment, I looked at the ANR interim procedure. I also looked at other state encroachment rules like Idaho's, which is very extensive. And I also looked at a program in Louisiana called the Inland Reefing Program. It's a program that they use for creation of artificial reefs and Lake Pontchartrain specifically. So I didn't want to get too detailed. I didn't want to get into like an Idaho 25-page detailed delegation of rulemaking, but I used some of the concepts. I mainly used the concepts of the Louisiana reefing program, and so that's what I've got as a framework. And so, do you want me to share the screen?
Yes, please. Thank you.
So can you see the screen?
Yes, sir.
So this is amending an existing section in Title 29 where the department has discretionary rulemaking authority to implement the requirements of the encroachment chapter. This would change it from discretionary to mandatory. It would require those rules to address the criteria for what adversely affects the public good under 29-405, including what constitutes an approved public use of the waters and lakes and lands of lakes and ponds under the jurisdiction of the department, provided that the criteria shall be designed to enhance and conserve fishery resources, facilitate access and utilization by recreational and commercial user groups, or establish or protect historical resources, minimize conflicts among competing uses of waters, minimize environmental risks and risks to personal and public health and property, and not create any unreasonable obstructions to navigation. Then the criteria for the creation of the rules shall also address criteria for the creation of artificial reefs or sinking of vessels within the waters under the jurisdiction of the department, and including the requirement that any creation of an artificial reef or sinking of vessel comply with federal rules such as the Rivers and Harbors Act, or guidance such as US EPA and US Maritime Administration's guidance for the sinking of vessels. The rules shall also address criteria for private docks, commercial marinas, private breakwaters, and private flood control walls or projects, and criteria for transmission lines, section lines, and other similar encroachments. In section 2, you have the date provisions. So on or before January 1, 2022, ANR shall initiate the rulemaking. And then on or before July 1, 2022, they shall file that final proposal of rules under 29 BSA 410 with the Secretary of State. And then the whole thing goes into effect on passage. The passage provision gives the agency additional time to initiate rulemaking. So you're probably looking at a 9-month rulemaking period here when all things are taken into consideration.
Okay. Thank you. And Senator McDonald, as you were the one who acted on behalf of the committee to get this amendment rolling, anything you want to add to that, or any comments on the form of the amendment? You know, like anything missing or?
It's more encompassing than I had imagined, but the drafter has certainly made a thoughtful recommendation that includes a lot of possibilities. So it's a step in the right direction, and I don't know if we.
Great.
And,
Okay.
Should I stop sharing the screen?
No, if you would go through it again slowly, just run it through slowly.
Okay.
Yeah.
So first, it's not drafted as an amendment to the capital bill because they had not yet made that decision. So it would likely be part of the capital bill and have different section numbers. First thing it's doing is amending the existing rulemaking authority for the department under the encroachment chapter. So 29 BSA section 410 is the discretionary rulemaking that the department has. Instead of it being discretionary, the department shall adopt the rules to implement the chapter. And then the rules shall address criteria for what adversely affects the public good. So the statute 29 VSA 405 says that encroachment shall not be provided if the proposed activity will adversely affect the public good. You could flip that and say for what constitutes a public good that qualifies for a permit, but I was just working off of kind of the structure of the statute as it exists today. And then that criteria for what adversely affects the public good include what constitutes an approved public use of the water on the lands and lakes and ponds under the jurisdiction of the department, provided that the criteria shall be designed. They will be designed to protect basically the existing uses of the water. Essentially, it's not saying the water quality standards, and it's probably shouldn't, but to enhance and conserve fishery resources, facilitate access and utilization by recreational and commercial user groups, protection of historical resources, minimizing conflict among competing uses of waters, minimizing environmental risks and risks to personal and public health and property, and not creating any unreasonable obstruction to navigation.
Mr. O'Grady, can I ask you a quick question on establish or protect historical resources? Could that be applied to the, I mean, I know there's a section coming on sinking vessels, but I'm trying to know whether or not establish a historical resource sounds like some of the argument given for sinking the Adirondack. And would that apply?
So there's already a historic underwater preserve program in the state that doesn't necessarily require the sinking of a vessel, but may involve other encroachments. So I think you could leave that silent, and the department is likely going to have to address it anyway. But I thought, because there is this program, that it should be referenced.
Sure. Okay. No, I just didn't know what it referred to. So thank you.
And then you go to sub 2, that the rules shall address criteria for the creation of artificial reefs or sinking of vessels within the waters under the jurisdiction of the department, including a requirement that any creation of a reef comply with federal rules, which they would have to if it's a Rivers and Harbors Act water, but also for guidance for such activities. And I think you've heard from the multiple interested parties that there is a US EPA and US Maritime Administration guidance document for the creation of artificial reefs from sunken vessels. And the criteria would address private docks, commercial marinas, private breakwaters, and private flood control walls or projects. And then criteria for transmission lines, suction lines, and other similar encroachments. Then you get section 2, which are the encroachment rules implementation. Agency would be required to initiate rulemaking. And I probably should say the department shall initiate the rulemaking, because Title 29 uses the term department. The department shall initiate the rulemaking by January 1, 2022. They shall file that final proposal of rules with the Secretary of State under 3 VSA 841 by July 1, 2022. Then everything goes into effect on passage.
Oh, Mr. Chair,
Yes, Senator McDonald.
just on a comment, this is from Louisiana?
It's based on Louisiana.
Okay,
It's
'cause-
not just
Yeah,
Louisiana.
yeah,
I use the
yeah.
concepts from Louisiana.
So it.
I also use,
Is remarkably confining for anything to come from Louisiana involving water. So they are notorious for allowing anything to happen in their waters, and have been for several decades. I guess getting into docks and things like that for commercial purposes, I don't know if that's where we want to go right now, if we're trying to set some guidelines for historic activities. But
so
that would be for the committee to wrestle with, I guess.
So could I just, I think there's been a lot of misunderstanding about where the jurisdiction for this issue lies. Yesterday, there was discussion in corrections and institutions about how this would affect historic preservation. Historic preservation doesn't have any authority over the use of or the encroachments on lakes and ponds in the state. That's a DEC authority. The briefing of the ferry was a DEC decision. It wasn't a historic preservation
Yes.
decision. So if you want to address criteria for encroachments, including reefing of vessels, it really should be with DEC unless you want to shift the authority to some other entity, which is your discretion because you're the public trust entity. So you can shift it to someone else if you would like.
But if Mr. Chair, and perhaps the reason you asked me to get this morning's discussion started was that the health and safety and pollution aspects had been reviewed for this project according to the federal guidelines. But if there should there be a limit on how much and how many things we can drop into Lake Champlain or other places, just because they happen to have been cleanly scrubbed prior to being dumped in the lake. I think that's and how much do we want to bite off here to begin with, and whether or not it's a worthy historic museum-like placement, or whether it's just a out of sight, out of mind junkyard. So that's what the draft is for, and I think the committee will no doubt deliberate. Thank you.
So thank you, Senator McDonald.
And thank the drafter for bringing these up for us to review. So thank you, Mike.
So if someone said without this amendment, where do we stand with current law? So were you saying, Mr. O'Grady, that it's under procedure currently? That's how these kinds of questions have been handled. And so by going to rules, it's a stronger, more assertive way of regulating, and that in your drafting, you tried to make it comprehensive as opposed to just addressing the reefing.
So the current program is ruled by statute, where there's a directive that the encroachment has to be within the public good, and that the entity needs to receive a certificate of public good from A&R. A&R has issued an interim procedure for the issuance or denial of encroachment permits that provides additional detail, things like exemptions to the permit requirement. My point is that that procedure, from my knowledge, is from 1989. Procedures are not really supposed to be of general applicability, and consequently they don't have the same force and effect of law, or should not have the same force and effect of law. And they're not subject to they're usually not subject to public participation. I can't say for sure if this was subject to public participation, since I was 19 and tending bars in Boston at the time. But generally procedure doesn't go through public participation. If you want public participation and you want more certainty in the force and effect of the law, rulemaking would be the way to do that.
Okay. All right. So any committee questions about the amendment language? Now we'll hear from some interested parties on the proposal. Okay. With that, I'd like to turn to Ms. Trishman. Good morning. Thank you for joining us.
Thank you very much for inviting me.
So you've heard probably more discussion than you ever thought you were going to hear about the Adirondack. And so you can see, the path we're taking is really, the committee is not taking any role relative to the Adirondack itself and the permit issued, just that to kick off a rulemaking to be more clear about it for the future. So I don't know what your thoughts are on this, if you want to address the rulemaking, and or if you want to talk about the individual permit already issued, or both.
Yeah, no, I think putting rulemaking in place is a really smart idea. Obviously I can't speak for Commissioner of A&R and all of that. But I can tell you that when the proposal was brought to us for the reefing of the Adirondack, I had a lot of the same concerns and even panic I'm hearing from other people. So we created 8 criteria for a vessel to be intentionally reefed in Lake Champlain and become part of the underwater preserves. And that is something that is in draft form now, but I am planning to make part of our Division for Historic Preservation rules. And we have shared it with the entities at the Lake Champlain Basin Program and the Maritime Museum, and others to really tweak this and make sure that it hits right the whole meaning of adding to the underwater preserves versus opening up existing wrecks that are already in the lake.
Okay. So if in 2 years' time, another vessel were to show up and it met those 8 criteria, you might recommend adding to the underwater historic preserves, or well, actually reefing another vessel. Is that true? I mean, I think
For us, yes, that would start the process. So that's when we would reach out to DEC, reach out also to House and Senate institutions, which addresses our funding for the underwater preserves. We've not been adding any preserves without having conversations with them. Because we do have limited funding, we don't want to stretch it and compromise the integrity of the program, but also the safety of the visitors and divers.
okay. Great. Anything else you wanted to share with us or committee members? Any questions from Ms. Frischman?
I would say that it's really important for us to make sure that the lake does not become just a junkyard, that not every vessel is eligible. So we really thought about this 8 criteria, and you don't have to meet just one, you've got to meet all 8 for us to even pursue the many permits needed for this process. I have been asked recently about sinking a sailboat that was over at Shelburne's shipyard from the 1970s. And that was a hard no for me. It was really easy to say no. So we take this very seriously. And I think the Adirondack in particular presents an opportunity different than our other underwater wrecks. And I think it would be really advantageous to tourism, to marketing of the program, to diver training, to safety trainings, because you can actually go inside the vessel, whereas all the others are wood vessels, at least 100 years old, and you shouldn't be touching them or going near them for the preservation of the vessel, but most importantly, the safety of the divers. So I see the partnership with DEC and the Army Corps of Engineers and the Coast Guard, and in this case with the Adirondack, the City of Burlington Harbor Master as really critical. And if any of those points start falling apart and we do not get permissions, then we would not be proposing to sink the Adirondack.
Okay. Thank you. Senator Campion.
Hey, Laura, it's Brian Campion. Great to see you.
Good to see you.
Really appreciate you being here. So I'm sorry, I just missed, when you said the 8 criteria, are these 8 criteria that are being met by the Adirondack before?
Yes, they are.
These are things that you've come up with in conjunction with DEC, or is this something that historical preservation has worked on its own?
It's historic preservation.
Okay.
But there is a criteria in there that says the resource must not present any safety or environmental hazards post-reefing, that it must meet the eligibility criteria for all necessary permits, including but not limited to permits from DEC and the Army Corps of Engineers. Those are 2 criteria.
Okay, thank you so much.
So, Mr. Chair, it may be helpful as an addendum to that to remind the committee that the permit that we issued highlighted the fact that that additional reefing would need to go through a more extensive test to prove that there was additional need for underwater diving activities. So it's not just a sort of, does this meet the idea of creating an opportunity, but to meet that public trust test, are additional diving resources needed? And so very explicitly in findings number 17 in our permit discusses that cumulative impact and the high standard at which further reefing would need to meet if it were to occur, because it is a different, it's, you know, sort of, with this scuttling, there will be a clear creation of that resource and that public good. And beyond that, we'll need to further evaluate whether or not additional resources are really needed. And that is the public trust test that is complicated to run. And we make sure that we do it in a fact-specific manner, but it builds on itself. And that's one of the benefits of the fact that we don't, you know, there isn't a sort of a standard, it's not your standard permitting process where you meet these criteria and you're good. We do look at the ways in which things add together in order to establish whether or not the public trust is being protected.
Okay. Senator Campion?
Thanks, Chair Bray. Well, Mr. Walk is here. I just want to, I know I've been asked by other senators, can you just give us a timeline for this in terms of the permit has been issued and when is the scuttling supposed to take place?
I would ask Ms. Drishman to answer the question about when, as she is one of the applicants. The permit has been issued, yes.
Has been issued, okay.
The plan is to intentionally reef it in the spring of 22, so next year.
Thank you.
Okay. So Commissioner Walk, you and Mr. Pearson are next on the list. So you see the proposed amendment before you. I'm wondering if we can get your thoughts on that as a productive path forward for this issue and lake encroachment more broadly.
Sure. I mean, this specific issue and whether or not to pursue rulemaking is obviously something we talk about a lot, right? In many instances, statute provides some level of guidance, and we provide greater clarity to all involved, the public, the regulated community, everybody, around how to comply. As I just mentioned, in the impact created by this reefing and what it would mean to future potential reefings, the public good test and the public trust doctrine is a very fact specific basis that the overall projects add to each other in terms of the impact on the public good. And so the development of specific criteria that would not necessarily honor that fact specific basis review. Certainly if there is a question about what constitutes relative to intentional reefings and around what the review should be there, I think that is something that we certainly could pursue in some form or fashion with public input. But the broader sort of conversation around lake encroachments as a whole, to me, doesn't fit well with the sort of development of a matrix of this constitutes acceptable level of impact and this doesn't, because we manage that in a much different way than your typical, sort of very specific standard-based permitting operations, for good reason. And so I just want to flag that for the committee as a place where I see some concerns. And I know Oliver has some specific concerns relative to things that are included, just that we don't really authorize as it stands now, because they don't have public good associated with them. The public good, as outlined in the reefing, was the creation of accessible diving opportunities for that were accessible to the public. That is the stated purpose, and we evaluate that relative to the impacts that you have previously laid out in statute.
So I guess, I want to make sure I'm understanding the proposed rulemaking and as laid out in this amendment. Are you supportive, neutral? Concerns usually means that there's a problem. So I don't know if you're asking us not to go this route at all, or you are thinking about proposing changes to how that rulemaking would be conducted.
From a broad sense, my large preference would be for you to focus on the criteria around what would be needed for further reefing of vessels. That is a discrete piece that we can develop clear criteria around, right? That are based on existing work that at the federal level, and to bring that to Vermont standards. That's a discrete piece of the matter. The larger criteria around how to interpret the public trust doctrine doesn't line up well for a sort of general class of criteria. And so that's where my concern on the rulemaking piece comes from. There's a danger in specificity when it doesn't meet that public good and meet that test. If we are, if in an additive or a cumulative basis, we wouldn't otherwise allow it to occur. And so that's where my concern exists. And you have delegated that authority to the department. We have taken that as a very solemn set of delegations so that we can ensure that we run that test fairly every time. And this reefing is a very specific subset of that. And I think that should be the focus of your efforts. We're happy to engage a public process around what that should look like moving forward, whether that's in rulemaking or the development of policy. That we're certainly comfortable with that. I think there has been a significant amount of public interest in this, and we want to make sure that we're doing it in a way that meets the public's desire. But I think it should be limited to that effort and doesn't necessarily need to be through a rulemaking process, right? We can have public processes around procedures or policies just the same.
Okay. All right, any committee questions Mr. Pearson, do you want to add anything to that? Or sounds like there's a bigger question first, whether or not we're going this route or not.
Yeah, I would agree with the commissioner. I think the public trust doctrine, as was stated, doesn't really lend itself to a quantitative review or a matrix of options. We apply it to protect current and future uses, allow public access to water, and generally protect water against adverse environmental outcomes. And the flexibility in our application of the public trust doctrine, I think, lends itself to taking each potential permit application on a case-by-case basis, looking at cumulative impacts, and avoiding being boxed into too many existing criteria. What's listed in section 1A through E of Mr. O'Grady's draft legislation is a good summary of our decision-making process that already exists through the interim procedures. And I'm still trying to figure out how a rule would really add a lot to the process. I'd also add that we issue about 40 lake encroachment permits per year. It's not a huge program, and it's a lot of public projects like bridge repair, boathouses. There's a fair amount of shoreline stabilization work, which, because of its impact on water quality, is perceived to be in the public good, even if it is happening on private property. And those types of projects, don't really fall into a category where I think there's a lot of concern or question about how to handle them, and the existing guidance and statute and the interim procedures allows us to make pretty well informed and generally non-controversial decisions. And so just sticking with what the commissioner said, this MV Adirondack project is a bit of an exception. And therefore, I think section 2 of the draft statute, which would have us do rulemaking around the creation of artificial reefs, Commissioner Walk said, policy or guidance, does make sense, and we'd be happy to put some specificity and procedures and integrate public comment around that. And I think that would best serve to enhance the overall lake encroachment permitting process. So I do have some specific comments on other aspects of Mr. O'Grady's draft legislation, but I think I'll hold those, as you said, Chair, in light of this broader discussion. Thank you.
Okay, so thank you. And I'm I was a little optimistic in my scheduling, so we'll work on this a little longer, and I think we're going to have to schedule another conversation to come to a conclusion. Mr. Groveman, can you have some thoughts on the choice in front of us and the language in front of us?
Yeah, thank you for the opportunity to address this issue. I'm just listening to the discussion and processing it, and it'd be good to have another opportunity because I want to think about what was said today. But I do think that I really appreciate the work of the committee. I do think we need a policy. As I said before, I think why I think Oliver is correct that most of the lakes and ponds encroachment permits are fairly routine and they're not controversial. I think this highlights a situation where we're sinking something into the lake, and it's a different sort of situation, and it does raise concerns and really important questions about the public trust doctrine and the public good and what are the policies. And I really appreciated what Laura said about them developing criteria, and I think that's great, except the public hasn't seen those criteria. We're not aware of them, and we're depending upon who's ever in these positions at any given time to make these really important decisions about our public waters. And the legislature is delegating that authority. So you're doing that too. So the less parameters around their decision making, we're really all really at the it really depends on who's there making those decisions. And so I do think we need a policy around at least what we sink into our public waters. I like the idea of a rule because it has the legal effect that Mr. O'Grady indicated. I would ask, I sent Senator Bray some language. One of the issues that I'm working with other groups who are interested and concerned about this, and we're thinking about whether we appeal the permit or not. We have to make that decision this week. One of the issues that we're concerned about, and I think it's just an evolution over time, but what does public good mean? And we're all talking about equity and diversity and inclusion now in all our policies. There's a bill in the House about land ownership and access to land, and groups that have historically been disadvantaged from those sort of opportunities or the use of public land. I think one of the things I see in the sinking of this particular ferry to serve this particular community is just a question of who's being served, who's benefiting from it. And the statute and the case precedent at the Water Board doesn't really look at the community being served, the size of the community. Is it a historically privileged community? What does benefiting all Vermonters mean in that context? And so I sent Senator Bray some language that I think if there is a rulemaking, it would be good to consider how to integrate those concepts into how we apply the public good to public trust waters that no one owns, that are managed for the benefits of all Vermonters. So you have the language, Senator, you could share with other people. I could email it to people, but if we do appeal, we're likely to raise that issue and ask the court to look at the statute. And we would argue that the public good definition is broad enough to include those concepts and they need to be applied. But I think it would be good to set policy around how we are implementing public good with an eye towards equity and inclusion and communities that have been historically disadvantaged.
So thanks for that. Honestly, I don't recall if it went to Jude as well? And if so, then it's usually posted to our site. So I will make sure that it's posted to our site and distributed directly to everyone on the committee. The thought I had around that inclusivity language, for instance, referring to communities typically disadvantaged communities, is that although I welcome it in this case, I'm just thinking that we might want to move far higher up the tree and have that mindset applied to much more broadly to rulemaking than just this particular rule being called for at this particular moment. And I don't know how you would bring that approach to rulemaking. As you said, that we're at some sort of inflection point, I think, as we think about equity issues in the country. And so it's not just an issue for this rulemaking, but for our bills and rulemaking more broadly. So
Yeah,
I'll make sure
I completely agree.
Yeah.
Thank you for that. This is the type of issue that kind of, and the language I came up with was in a bill that was dealing with access to land. So, I mean, I think all our policies, like you're saying, I think we're going through this, we're at this inflection point where we're looking at all of our policies that deal with public lands and public waters and public resources and these equity issues. So,
right. Okay. So we'll have that on the website and distributed to all committee members directly to make sure. And Senator McDonald?
So, I thought both Mr. Walk and Mr. Pearson raised good points on perhaps limiting the rulemaking to the museum and historical nature. That the first, and during those hearings, we would have witnesses that would bring up the issues that in the rulemaking, John Groveman has brought up, and it'd be an opportunity to do a narrow focus in making the rules, but learning a lot more about other issues that might be future legislation. And that would seem to me might be a useful way to approach this. So,
I think the way I would propose that we leave it is that we schedule some additional committee time to discuss the path forward, and we'll stay in touch with all the parties. And we can also look at Mr. Groveman's language in between and consult with counsel as well on our side to think through the options in front of us. So I appreciate everyone's continued work on this. This is one of those issues. The more you learn, the more it raises some questions, and we'll be patient and keep working on it till we have a solid proposal to recommend to our colleagues. Senator McCormick, in terms of institutions, our connection there, then I would say if you could share that the committee hasn't finished its deliberations, that the capital bill, we don't want to hold it up. It'll go out. I talked to Senator Benning, if we missed the capital bill coming out of committee, that we could bring it to the floor, and he thought that would be, it's also going to be in appropriations for a little while. So we have two chances to catch up with the capital bill, one in appropes and then later on the floor. And either way, he was fine with doing it. It would have been tidier to get it to you now, but that's premature. So
Are the two of you, the two chairs, imagining then that the Natural Resources Committee would offer an amendment to the capital bill?
yes, and then
Because we were trying to avoid that. That's
Yeah. right. Well,
we can't do that, but we can, as individuals, do that, and individuals could include members of the
yeah.
senators on both committees as they chose to propose, be party proposing amendment or not. So,
Right.
it's just a parliamentary distinction.
Since we have A&R here now, I want to be fair. I'm not convinced, and I want to make sure I at least understand A&R's position accurately. If I'm hearing, what I'm hearing is that rulemaking, an amendment requiring the rulemaking process would be redundant because A&R already has a process. And the reason I'm not convinced about that is that process allowed for the sinking of the Adirondack to be permitted. And that would imply to me that perhaps we're not looking in the right places when considering permits. Convince me that I'm wrong. Correct me if I'm misunderstanding you.
So, Senator, I'm not going to touch the second part of your argument because you're making an argument about the validity of the permit we issued, and I understood we were not going to have that conversation that we were going to
Okay.
going forward. The issue that we've raised is that the specificity of what you do here in terms of what you want us to do rulemaking on, it is that it's our preference to have it be very clearly based on the issues around potential future reefing, intentional reefing of ships. That is the issue at hand. In order to fully execute the public trust doctrine effectively, as Oliver mentioned, we need to have flexibility and the ability to look at cumulative impacts, and it doesn't lend itself well to a clear sort of matrix of if you meet these criteria, you're good. We want to make sure that there is a full evaluation, a full fact-specific evaluation every time. And so that is why we think that the other provisions of the rulemaking that are in the current draft do not make sense as relative to this specific case or to this specific area of the law. It is a question to me, we hear you that you would like to have more specifics and more public discussion around what constitutes an appropriate reefing of a ship. We hear you.
Yeah. Okay.
So
I would like to not have Lake Champlain used as a dump. That's really my position. And it seems that right now, under the present process, we can use Lake Champlain as a dump. And the justification is we have an A&R permit to use Lake Champlain as a dump, which makes me think I'd like to do something about the permitting. Since the permitting process is supposed to implement the law, and the law allows for a permitting process that allows for using the lake as a dump, then I think we, the legislature, ought to do something about the law.
Okay. So I would propose that we pause for now and come back to this when we're going to have a chance to get into it. I mean, I suppose if I were to try to summarize what I'm hearing, with all due respect to the current interim procedure, that this reefing was past the test to allow for the permit to be issued. And why not yet another ship? What will be different about a substantially similar future application under these current interim procedures that would lead to a different outcome? So I think that's where the committee's discomfort lies. And it sounds as though we're not, if we do not act, we think we might, it would be reasonable to expect the same outcome again. So I think what we're trying to do is find a way to prevent a similar event from happening again. And if we leave everything intact, why would that not be a reasonable concern?
Senator Bray, if I could just address that quickly again, so the permit that we issued for the reefing specifically addresses that point and says that the criteria under which we would evaluate future reefing changes with the issuance of this permit, because the public good is based on the access to sufficient whatever amount of diving accessibility in our underwater preserves. That changes the test for future applicants. And that is why the public trust doctrine needs that flexibility to be able to manage those cumulative impacts. And it is specifically that piece. So that permit sets the new baseline for our evaluation. And I just want to make that abundantly clear to everybody.
Right. Okay.
Senator, can I address that just because I mean, I don't want to get into arguing about the permit, but again, it goes, I mean, we don't know who's going to interpret the next time this happens and interpret that provision. And that provision doesn't prohibit another reefing. It does change the facts and circumstances that could be interpreted by whoever is in power to issue permits as, well, the next one's allowable too. And maybe the next one, but maybe not the next one after that. We just don't know. And that's why I think having policy and sideboards is the only way to control a different outcome. All those permit conditions are subject to interpretation and argument, and they will be interpreted and they will be argued. It's not rock solid. Just not.
I'm not suggesting it is. What I'm saying is that's why we're interested in doing this process around making clear what the criteria are, but to limit to that needs to be a criteria that we would evaluate within the concept of the public trust doctrine, where we're looking at public good versus the potential impacts. And so that we don't end up in a situation where we establish numeric criteria for potential future reefings that doesn't account for that the sort of overall impact over time. And so that was the piece that I was trying to make clear.
Okay. So, Senator McDonald, you started us off. You can wrap it up.
Mr. Chair, we don't have dumps anymore. We have sanitary landfills. And the process that is approved this briefing appears to have met the standard of sanitary landfill. And now would have rules around what can you put in a sanitary landfill. And this proposal is to at least put some rules around having to do with historical importance or the historical importance around those rules. And in the process, we can get through this step and open a wider discussion to how to deal with the other issues that Mr. Walker has talked about. And we'll probably do it as you've suggested by ending the conversation now and pursuing a modified version of what we have before us. Thank you.
Well put. Okay, so we will schedule time again. Senator McCormick is a member of institutions. If you let them know that we'll keep on working in a timely fashion along to come to a resolution, but we're not ready to send language over to the institutions committee today.
So what are we suggesting that, because I think institution wants to get the capital bill out fairly quickly. Are we suggesting them just
So yeah,
do it the way it is?
right. When I talked to Senator,
With their amendment, our amendment, I'm the minority vote on it, but the institution's amendment with the expectation that we will be back in touch
yes, yep.
later. Okay.
Yeah.
Okay.
I mean, and when I talked to Senator Benning, we had plan A, B, and C. A was getting it to you while I had the bill. B is while it's in approach. C is while it's on the floor. So we'll keep after it. Thank you.
Well,
Thank
let me just say
for your.
Let me just say very briefly. Administrative agencies always have flexibility by definition. It's called administrative discretion, but the flexibility is within the law. The legislature decides what it is the administration has to make happen. They get to decide how they're going to do that. That's administrative discretion. But it is always, all administration is confined by the law, and the legislature writes the law. We're not taking away the administration's flexibility by telling them, this is what you're supposed to enforce.
Okay. So thank you, everyone. We'll keep working on this, and we'll schedule a follow-up meeting this week. Okay. So we're going to change gears to talk about Act 250 now as it relates to ARPA money. My mistake, I didn't realize that Stephanie Barrett, who had come in to give us a short list review of current ARPA funded proposals of interest to this committee, has had to go on to another meeting. I just wanted her to we'll get that document so everyone can be reminded of what proposals are out there for ARPA spending that lands in the jurisdiction of the Senate Natural Resources and Energy. Amongst those proposals are, there are some language that relates to Act 250. And so I wanted the committee to be able to keep up to speed on this proposal because it's not moving directly through our committee. And I wanted to make sure that Ms. Schakowsky could help us learn about where it's proposed and what it's moving with, and what the implications are. So with that, I didn't mean to
I don't
change
know.
what I was
I don't
asking.
know if I can answer those last questions you just
Well,
stated.
was it?
But I will do
yeah.
my best to give you an overview of what is in the governor's proposal. Ellen Tchaikovsky, Office of Legislative Counsel, although I will say, I think it would be very important for you to hear directly from the administration. I did not write what I'm going to show you, and I have only heard some of the explanation that was provided last night to House Natural. So I do not know all of the details of this proposal. But I can talk to you about some of what is in the proposed draft. I also do not quite understand procedurally what's going on right now because this, the state budget is moving through the Senate Appropriations Committee currently. It has already passed out of the House, but the Senate committee, I think, is working to wrap up its work. And I do not know to what extent any of these proposals have been reviewed by the Senate Appropriations Committee because I don't work very closely with them. So I don't know where they are in their process. So
Do you know where this language that we're going to look at is? Like, is it in a housing proposal or a?
I don't think it exists in a bill.
Okay.
So what I have had, so on your website today under my name, Jude has posted the draft that was provided to House Natural yesterday from the administration. I don't know if this is actually in a bill anywhere, so I don't know that.
Okay.
It's a pretty recent proposal, so
Right.
I don't know if it's been incorporated.
Well, we have, as luck would have it, or maybe more than luck.
I was going to say, you might want to sign off quickly.
Commissioner Walker is with us. So I hadn't asked you to prepare to talk about this, so you could wave us off if you need to look into something. But I was just all I've been aware of is that there was language that affected Act 250 traveling as part of the ARPA funding proposals, and not even knowing where that language is and what it relates to. But I wanted us to track any money that was related to this committee's jurisdiction and any language were related to this committee's jurisdiction. So I don't know if you might be able to point to where the language is. My guess was that it was going to be related to housing again, but I don't know that.
So again, for the record, Peter Walk, Commissioner of the DC. I did note your schedule and thought it might be useful to stick around. So it's not totally accidental. I guess we are in a bit of an odd situation given the sort of nature of the ARPA money and when it was passed through Congress and how those things have occurred. And to my knowledge, the proposal that the administration has put forward in terms of the appropriations language doesn't exist in any bill form currently. And what we are asking for it to be included in is the big bill moving forward. And so that's the nature of that request. Relative to the Act 250 pieces, I would need to probably bring others in for that discussion. But I can certainly speak to the nature of the proposals we put forward, as we've talked about to some extent with you already around the water infrastructure work.
Okay, so for the Act 250 related proposals that the administration would like to see travel in the big bill, what's the best way to get to see that language? Like, can you send it to this committee, or Ms. Schakowsky, you already have it?
Right, so it's on the website today under my name.
Okay,
It's at the end of the proposal, sections 5 and 6, I believe. So
you want to
So
screen
I
share?
believe that is the
Look at
most
it?
recent version, because this is the language that was in House Natural last night. So it starts on page 13, and I'm prepared to sort of review it with you and put it on the screen. I just have read this document and I haven't,
Sure.
so that's what I am prepared to do.
Okay, so let's just do that. So we'll all come up to speed a little bit, knowing that there's more to come.
So, as I just mentioned, under my name, there's this document titled the Governor's ARPA Funding Proposal that Secretary Moore reviewed last night with Senate, with House Natural Resources. So I think this is the most up-to-date version, but I'm not 100% certain. But starting on page 13, section 5, permit expediting federal stimulus. So notwithstanding any other provision of law, the following shall apply to an application for a permit, certificate, or other approval to the Agency of Natural Resources, the Agency of Transportation, the Department of Fire Safety, an appropriate municipal panel, so a municipal panel that issues a land use permit through a municipality, or a district environmental commission under Act 250, with respect to a project that will receive any of its funding through the Federal Rescue Plan Act, the ARPA Act. So first, the application shall be given priority over pending applications unless a pending application represents an action to resolve an urgent public health or environmental issue. So priorities in the application process, and this says projects that receive any of its funding through ARPA. An appropriate municipal panel shall adjourn the hearing promptly after all parties have submitted evidence and argument and issue a decision within 30 days after the adjournment of the hearing. And failure of the panel to issue a decision within this period shall be deemed approval and shall be effective on the 31st day. So this language is similar to language that's in 24 VSA 4464, which dictates that a municipal panel that's having a hearing on a municipal land use permit shall issue the permit within 45 days after adjournment. So speeding up the timeline on that by 15 days. It also includes this word promptly, which is different from the statute. And that's similar in this next subsection, subsection 3. So a district commission shall adjourn the hearing promptly after all parties have submitted evidence and argument and issue a decision within 60 days after the adjournment of the hearing. And failure of the commission to issue a decision within this period shall be deemed approval and shall be effective on the 61st day. So this is directing that municipal land use permits and Act 250 permits, the hearings on those permits need to be adjourned promptly and then issued within a specified time or deemed approved.
Okay.
So
1 is a go to the head of the line, and 2 and 3 are like there's a shot clock, act within this time or it's deemed approved. Whenever I see an adverb or an adjective, it always is like a red flag. So what constitutes promptly? And I don't really understand why you would need to direct a panel to adjourn.
So currently in statute, the Act 250 statute is phrased a little bit differently. Currently in 6085, district commissions shall adjourn a hearing reasonably as practicable after, and then issue a permit within 20 days of adjournment. And so district commission proceedings, after the hearing, I think it's pretty common for the district commission to actually ask for additional evidence or information after a hearing. And so after a hearing, they don't always adjourn right away. So this is dictating, I believe, that after the hearing, the shot clock starts. So no more back and forth.
Okay, so we have a district commissioner, chair of a district commission in the room. So Senator McCormick, sorry, you want to fill us in with like a narrative? Like if you were sitting on a district commission still, how does this give you pause in some way?
I'm just getting this now. I mean, my quick answer is I'd like time to think about it. First of all, you wonder about going to the front of the line. Don't we have like 3 years to spend the money? What's the rush, I guess, is my first question. Why do we put these projects in the front of the line at all? And I don't know if that's because I was once the chair of a district commission. It just, in my present capacity, I wonder about that. And as far as the 60 days, first of all, I think the vast majority of Act 250 applications get a permit within 90 days, I believe. Don't hold me to the exact statistic, but they tend to be fairly timely. We get the horror stories about the ones that take years. Often that's simply the applicant fighting over jurisdiction. And once the applicant loses that fight, then they get a permit in a reasonable amount of time. And usually there's some serious reason for controversy if it lingers. The typical thing is 90 days. But I'm reluctant to give you a facile answer right now, Mr. Chairman.
Okay, sure.
That's my first reaction.
None of us knew. None of us have seen this before. We're just
yeah.
catching up with a proposal. Okay.
Well, I guess so where I would like us to, as we catch up, is what's the rush? Given that last time we had like, what was it, 6 or 7 months? We had to spend all the money by the end of the year. That's not the case here. And then secondly, I don't know if the 60-day deadline is, I think it's sort of a solution looking for a problem. And when it goes longer than that, there's often a good reason.
Okay, thank you.
Just say that.
So Commissioner Walk, again, we didn't ask you to come in here and present this. I don't know if you want to informally share any thoughts on why these provisions are being offered.
Sure. I think the Senator McCormick brought up an excellent point around the timeline. And so the sort of like, let's think about the arc of one of these projects. The projects that were done under CRF were for the most part near term, ready to go, or monies that were going to backfill things that were needed for state park sanitization work and other things that were easy solutions. As in the governor's proposal, there is a significant amount of money for creating housing opportunities in Vermont. And so the lead time of that in terms of designing and planning to permitting to construction needs to be done in that 3.5 years. And so each one of those periods of time can take a significant amount to get ready. And so the idea is to provide my agency and others with the resources to be able to do these expedited reviews so that they can get done and work their way to construction quickly, so that we make sure that we don't leave opportunities on the table. And that's really what it's designed for. It's the combination of resources so that others aren't being sort of held back at the same time, and the expediting that really is what come together.
Okay. Thank you for that. All right. So Ms. Chakowski, back to you. Any more comments that you want to share with the committee on 1, 2, or 3?
Sure. So I already mentioned that under Title 24, currently the panel has 45 days to issue a permit. So we're shortening that deadline by 2 weeks. And for Act 250, it's currently 20 days after adjournment. So this language is sort of changing that process slightly. I haven't, it's unusual to me because I haven't reconciled how these two things work together. The existing statute and this proposal. I did also want to add that currently in statute, the downtown developments have an expedited process also that says that the district commission shall issue a decision on a downtown development expedited process within 60 days of the application being complete. So that is a different timeline that's also currently available for the downtowns specifically. And then it has to be within 15 days of adjourning that hearing. So again, a slightly different. And then one other thing in 6083, so currently there's a statute 6083E, the district commission shall give priority to municipal projects that have been mandated through state permits, orders, settlement agreements, statutes, rules, or policies. So there is already an existing priority specific to municipal projects that have been mandated. So there is some precedent for this idea that projects that have been dictated have some priority. So that's just some other statutory context on this.
Okay. Yeah, so for you as an attorney, when you read shall adjourn the hearing promptly, is that clear? I mean, for instance, Senator McCormick was citing you might ask for additional information, which seems like a very legitimate thing for a panel reviewing something to do, like they need more information on. Would it be correct to say that the application's not administratively complete until the additional requested information has been provided to the panel? I don't know when the administratively complete clock starts.
Administratively complete starts when the district coordinator rules that the application is complete.
Right. That's
And then there is
milestone, right?
Which is well before the hearing. And so then there are arguments and evidence submitted by the parties to the application. So, right, so 6085, the current statute currently reads, a hearing shall not be closed until a commission provides an opportunity to all parties to respond to the last permit or evidence submitted. Once a hearing has been closed, a commission shall conclude deliberations as is reasonably practicable. A decision of the commission shall be issued within 20 days of the completion of deliberations. So this language seems to be changing that process, and I don't have I haven't fully thought through it, but
Sure.
The statute lays out that after the hearing is closed, the commission deliberates and then issues within 20 days. And that period of deliberation is sort of when time can pass. So I don't quite know how this would work in practice. Perhaps you could hear from the NRB.
Okay, great. So thank you. Let's there's one more section.
Well, so actually I'm going to jump quickly to page 6 because related to this, on page 6, there's language in the money part of this that says expedited permitting. So 1.125 million is appropriated to expedite Vermont's permitting processes. And this appropriation is divided as follows: 375,000 to A&R to provide administrative support to prioritize and expedite permitting for the ARPA projects, 375 to the Natural Resources Board to provide administrative support to expedite and prioritize, and then also to the Division of Fire Safety. So potentially adding additional staff to assist in the expediting. So it seems like potentially the municipalities may also need staff, since they're also being asked to speed up their permitting process, but I don't know if that's in here anywhere. So that's just another piece of this specific proposal.
Thank you. Commissioner Watt, do you have any gloss that you can offer on that? Is that, equivalent to, I don't know, 3 hires, 2 hires per named entity there or something?
Yeah, so we equate full-time equivalent employee to $125,000 roughly. So 375 represents 3 people.
Okay. And so I know that there's a concern about committing to ongoing expenses on one-time money. Are these fixed period hires or something like that? So while we're doing this work, you have that staff, but it's not a permanent increase in staffing.
Yeah, these are intended, and I believe elsewhere in the language is sort of lining out the limited service positions associated with this work.
Okay.
So it is intended to plus up for this level of additional activity and then return to previous staffing levels in the future.
Okay. So that would be, this is an appropriations question, but I'm just wanting to understand. So that 375 staffs, that's plussing up for 1 year. And is that how long are you, it's possible that you'll see the demand and there'll be another appropriation the next year to keep people on for a second year or something like that, depending on the need?
Yeah, as we talked about it, we've talked about it a couple of times in committee, the idea being what we know now about what money is available and what projects would be eligible. It makes sense to do this on a fiscal year by fiscal year basis, right? Because if there is significant additional infrastructure dollars with specific goals associated with that, we may be able to adjust priorities in year 2, but that is a sort of future unknown at this point about whether that's going to happen and what it's going to look like. So we're planning for this fiscal year, and that's the nature of the request.
Okay. Okay, great. And is ARPA money eligible for staffing for administrative processing?
It is my understanding that is the case, yes.
Okay, great, thanks. Mr. Chakowski, you've moved our screen, so I'm guessing you have something more to share with us.
Oh, well, we haven't even gotten to the Act 250 language yet.
Okay.
So the rest of this document has proposed statutory language relating to Act 250. So Section 5 talks about expediting and prioritizing. Section 6 talks about exempting projects from Act 250. So it adds a new subchapter to Act 250 to provide an exemption to Act 250 for projects that receive ARPA funds and are located in specific areas. So any development project funded in part by ARPA and located within an ARPA development zone, which includes designated downtowns and village centers that have a duly adopted and regionally approved municipal plan and duly adopted permanent zoning and subdivision bylaws, including flood hazard and river corridor bylaws. and neighborhood development areas and existing industrial parks. So downtowns, village centers with zoning, NDAs, industrial parks. Any person proposing a ARPA-funded project located entirely within one of those 4 areas may obtain a jurisdictional opinion from a district coordinator. And they shall provide the district coordinator with documentation sufficient to verify the project has ARPA funding, project description to document the use, total square footage of each component of the development, and all involved land proposed to be used for the project, and a site plan. Any project deemed to be an ARPA-funded project that is not required to obtain a permit or a permit amendment pursuant to this chapter shall file a site plan with the district coordinator within 3 months of the completion of the project. And then these JOs shall be published online. So ARPA-funded, located in these located entirely within these areas, they go get a JO from the district coordinator and they're exempt from Act 250. And then they file a site plan within 3 months of completion of the project with the district coordinator. Which is actually, sorry, that's the next section. So no permit is required for these projects. If the land does not already have an Act 250 permit. No permanent amendment is required for an ARPA-funded project located entirely within these areas. If the project will comply with all conditions of an existing permit or permit amendment issued pursuant to this chapter that applies to the tract or tracts of land on which the ARPA-funded project is located. So I kind of have a practical question of in what scenario that would happen, because I suspect many Act 250 permits say you shall not construct anything additional without getting an updated permit. So I'm not sure how these construction projects could comply with all of the existing Act 250 permit conditions. But if they do, and if the JO determines that, so no permanent amendment is required if this project will comply with all the existing conditions on the Act 250 permit. But if they will not comply with one or more of the existing conditions, they have to file an application pursuant to the next section. In order for exemptions in this section to apply, a jurisdictional opinion must be issued. So they do have to get a jurisdictional opinion. So this section concerns an application for a permit amendment to change the conditions of an existing permit in order to authorize the construction of an ARPA-funded project. Notwithstanding any provision in this chapter to the contrary, district commissions may authorize a district coordinator to issue such an amendment without a notice and a hearing if the applicant demonstrates that all parties to the existing permit which contain the conditions proposed to be changed or their successors in interest have consented to the proposed changes to the conditions relative to the criteria for which the party obtained party status. Okay, so ARPA-funded projects, if they're going to move forward and not comply with one of the conditions, if they get permission from all the parties to the original permit, then they can move forward with a district coordinator authorized amendment without notice and a hearing. But then if the applicant is not able to obtain the consent of the parties or their successors in interest with respect to one or more of the conditions in the existing permit or permit amendment proposed to be changed, The notice and hearing requirements of 6084 shall apply. However, notwithstanding any other provision, review by the district commission shall be limited to whether the changes to conditions not consented to by the parties enable positive findings to be made under this Act 250 criteria and authorized under the permit conditions section in 6086C. And I'm not entirely sure what that means. It is directing that it be a limited review by the district commission. I think it's suggesting that. I haven't fully digested what that hearing would actually sort of look like. So then I think we're almost done. So any change proposed to an ARPA funded project that was not required to obtain a permit pursuant to this subchapter, and which is not itself ARPA funded, so future changes to ARPA funded projects must be authorized by a permit issued pursuant to this chapter if the change constitutes a substantial change. For purposes of this subsection, a substantial change to an ARPA-funded project shall be analyzed in the same manner as a substantial change to a pre-existing development that is analyzed pursuant to board rules. So pre-existing projects that existed pre-1970 and before Act 250 went into effect use this substantial change analysis. It is similar to the material change analysis that is looked at for permit amendments. But this is saying that in the future, these ARPA funded projects that don't have permits may need to get them in the future if they undergo a substantial change.
Is substantial change a less of a change or more of a change than a material change?
So I'm going to say I don't know the answer to that because the standard is pretty similar. So the standard for material change is any cognizable change to a pre-existing project which may result in significant adverse impact with respect to any of the criteria. And it's very similar to the material change standard, which is also any cognizable change to a permitted project that may result in a significant impact under any of the findings, conclusions, or conditions of a project's permit. Or would have an adverse impact under one of the criteria. So I think they're almost the same standard, but I don't know specifically.
Okay. All right.
So then finally, oh yeah, we're running out of time here. Jurisdiction over certain state transportation facilities. So notwithstanding any other provision, no permit or permit amendment is required for the construction of a federally funded highway transportation and structures projects that are to be used for municipal or state purposes and for which a public hearing for a new right-of-way acquisition, an application for a state or federal permit or authorization or construction has commenced prior to December 31st, 2027. I don't understand all of the terms in this section, but this is exempting certain transportation projects from Act 250.
Okay. All right. Well, and is this, I see effective dates coming up. So.
Yeah, so it's effective on passage, but then there's repeal language. So there's sunsets this last part, there's a sunset in December 31st, 2027. That's real. I don't quite know where that date comes from. I see that it's related to the transportation, but I don't specifically know about that. So.
Okay. Plenty more to learn on some, I would say, very substantial proposed changes for Act 250.
Right. So high level exempt downtowns, village centers with zoning, NDAs, industrial parks, using any ARPA funding from Act 250.
Okay. All right. I think any committee questions as they relate to the text. If not, if you could stop screen sharing, we can see each other a little better, and then we'll wrap up for the morning. Senator McCormick.
Thank you, Mr. Chairman. I don't think we have enough time before we break for all of my comments. I just want to say I find some of this language really alarming and very familiar. And I hope we will take a good hard look at it.
Right. Thank you, Senator Campion.
Where is this in the process, Mr. Chair?
So it's a little squishy, but I think the proposal is that this will travel in the big bill. Mr. Chakowski was just saying it was presented by the secretary last night or yesterday afternoon, whatever, in House Natural Fish and Wildlife. I think we'll want to act promptly. My take on Act 250 is that we should be cautious and prudent about changes, and given the speed at which there could be pressure to move something along right now. I want to reach out to I'm going to reach out to Senator Kitchell, and Senator Westman's on the committee.
Yeah, Mr. Chair, if I may, I just don't see, we have tomorrow really, because things are going to be advanced possibly on Friday. I appreciate, the presentation and everything, but I don't see where we act on. We just don't have the time. That's just me. That's where I'm sitting. I think we're all in that tricky spot right now as well. Squishy is a good way to describe it. It's not a lot of time and a lot of different requests.
Well, so I'll put my cards on the table. My position on Act 250 is, when in doubt, don't change it. It's a foundational land use law that's stood us in good stead for 50 years. So I'm not wedded to every word that's in there, but I would want to make sure that everything that we ever proposed for a change was well vetted. And that's the problem here. We won't have the opportunity to vet these things well, I don't believe. So I think, would I be correct in speaking to the chair of appropriations and saying that at this point we couldn't support the inclusion of this language in the big bill?
That's from where I'm. We just don't have time.
Yeah. So let's just poll ourselves informally here so that I can have that conversation with Chair Kitchell. Senator McCormick, I think you've already weighed in. Senator Campion, I know where I am. Senator Westman and Senator McDonald.
I texted you, Mr. Chair. This is a pattern here. Getting a lot of last minute proposals to go on bills. And if we do the right thing, the bills are going to go into effect and then we're going to get whacked.
Right. Senator Westman, any thoughts about this one?
Nothing right now.
Okay. Well, you at least have a seat at the table when this comes up. So,
well, when is it going to come up?
Well, I don't. we're back to the squishy part.
I was just wondering if somebody could tell me when it was going to come up. We're going to vote the appropriations bill out on Monday. Okay. To my knowledge, as far as when we left committee yesterday, and maybe there's been a change, It wasn't on our schedule.
Okay, so
So,
maybe it's going to travel from the House over to the Senate. And
well, my question would be, how can it do that if it's going in the big bill?
Right.
The House sent their bill over to us, and the last I knew, if once one body sends the bill over to the other body, they can't take it back and amend it.
yes, well, I agree. I'm just,
I was just wondering what the plan is, and
Right.
when you find out, I'd be interested to know.
Okay, I'll do that. So thank you, everyone, for walking through things and keeping things moving. It's hard to put things to rest at this point of the year, but that's okay. I'll check in with Chair Kitchell. We'll get better clarity on the pathway here and what's being proposed. Ms. Chakowski, thanks so much for giving us an overview. So now we know it's in play somewhere, and we'll, depending on what I learn, we'll schedule ways to follow up on this. So with that, it's a little